Hey, what's up, guys? Today we're going to be starting episode 1 of a series where we deal with KRMC law on behalf of CIBC going through a debt dispute. So to give you some background on the case, essentially the debt dispute was started by a debtor serving CIBC a registered letter stating that they've arranged private financing to pay the debt out in full. But due to the assignment clause within CIBC's cardholder agreement that states that they can sell the debt at any time without informing the borrower would simply like to receive verifiable proof of ownership, just verifying that CIBC hasn't sold the rights to the debt and are now attempting to collect on a debt which they no longer own the rights to due to the fact that they may have sold it. So today we're going to be addressing the first in communications with CIBC's lawyers where they allege that requesting proof of ownership of debt before paying them out in full is an OPCA scheme. Now, for those of you that don't know what an OPCA scheme is, OPCA stands for Organized Pseudo-Legal Commercial Argument. In other words, a legal argument which is not based on legitimate law or legal principles. Now, the concept of proof of ownership is so ingrained in our society that you can't even leave Walmart without a receipt proving that you own the items that you purchased. When buying any type of asset, proof of ownership is involved, verifying proof of ownership of the seller. When you go purchase a vehicle, you obviously need the title to make sure that the seller is the rightful owner of the vehicle. And this is just to ensure that you're not purchasing a stolen car. When you're purchasing a house, you go down to land titles and make sure that the person selling the house is on the land titles and is willing to transfer that title over to you. Requesting proof of ownership of an asset before handing over funds is very commonplace in all business transactions, and to try and claim that as soon as you step into the realm of finance, that legal principle of proof of ownership should just dissipate is absolutely insane. So now we're going to look at a letter from Sandy Labib of KRMC Law, the law firm representing CIBC, and we're just going to pick apart their argument and show you guys exactly how we responded. And in the next episode, once they respond, we will go over that as well. So here is the letter which was received by the borrower from KRMC, and it reads, feel free to pause this and read the letter in entirety, but it essentially just says, we're the lawyers for Canadian Imperial Bank of Commerce, CIBC, in the above noted matter. It appears from the communications that unfortunately you've been exposed to an organized pseudo-legal commercial argument. OPCA pseudo-law schemes are proliferating over the internet. They incorrectly indicate that a person can follow such schemes to eliminate their debts without paying them. However, OPCA pseudo-law schemes have been universally rejected by Canadian courts. Please refer to the case Meads versus Meads in 2012. Now, I highly suggest that you look into Meads versus Meads yourself because it is hilarious. It's like something off of a Saturday Night Live skit, okay? First of all, it doesn't involve any banks or private lenders, so I'm not sure where they're drawing comparisons in that sense. What Meads versus Meads is a custody dispute about two spouses going through a divorce, and the husband, Meads, claims that he doesn't have to pay child support because he's a child of God. Therefore, he's governed under the law of God, and Canadian law does not apply to him. So this could not be more off the mark of a private lender requesting proof of ownership of an asset before they forward funds. And the fact that they would even include that in this letter, it doesn't really make any sense because they must be assuming that no one's going to go and look into this because it's so apparent that Meads versus Meads has absolutely nothing to do with requesting proof of ownership of an asset before forwarding funds. And this is very clearly just an attempt to use legal mumbo jumbo and an official letterhead from a legal firm representing CIBC to scare debtors and dissuade them from exercising their rights as a debtor in a transaction to receive verifiable proof of ownership of an asset before they forward funds. And I mean, that applies under any situation, not just finance. In any situation, if you're forwarding funds for an asset, you have a right to verify ownership before you forward those funds. So again, this is just an intimidation tactic. They don't want to let a chartered accountant into their ledgers because a chartered accountant is governed by a third-party agency which will take away their license if they make any reports that are untrue. So CIBC doesn't want to let a chartered accountant into their ledgers because a chartered accountant is not going to say that they still own it if they've sold it. So for whatever reason, CIBC doesn't want a chartered accountant snooping about in their ledgers, and they most definitely don't want to provide us with verifiable proof. So therefore, they're just going to try and intimidate the debtor into running away or laying down. So here we have the debtor's response to that letter, and I'm just going to read it verbatim. Again, try and pause the video and read through it in its entirety so you can really understand it. Essentially, all it says is, first of all, I do not believe verifying ownership before a transfer of funds for an asset is an OPCA scheme, as it is a fundamental building block of the Bills of Exchange Act and all transactions within commerce. To claim such a thing is ridiculous. I would also like to point out that I have a legitimate private lender willing to pay the balance in full, contingent on the receipt of verifiable proof of ownership. Upon your request, I can provide any documents needed to verify the legitimacy of the private lender. I will have them reach out to you via email stating they are my private lender and will provide proof of funds. Second of all, I would like you to show me the parallels you are drawing between the cases you have referenced and my position. In none of the cases referenced do I see a private lender with all the funds arranged. Meads versus Meads doesn't even involve a bank and makes outlandish claims such as not having to pay child support due to being a child of God that do not parallel my position in the slightest. I am not a sovereign citizen. I am simply practicing common sense business practice and am wary to hand over funds for an asset to those who cannot prove they own the asset in question. Do you think it is reasonable to expect me to pay for an asset which CIBC cannot prove they own? Furthermore, how could this be an OPCA scheme when there is a legitimate private lender with the funds ready and available to pay CIBC in full upon receipt of verifiable proof of ownership? None of the OPCA schemes that you are referring to involve legitimate private lenders with the funds ready and available, contingent on a reasonable payout condition. I will be having my private lender reach out to you to provide proof of funds and verify their legitimacy. Again, now we put Sandy to the task of answering the following two questions. How could this be an OPCA scam when I have a legitimate private lender willing and able to pay the entire balance? And second, and most importantly of all, are you aware that debts are bought and sold as a daily business practice via the process of securitization? So now I want us all to just take a second here and think. Why is it that CIBC couldn't just simply have an accountant check the ledgers to confirm ownership? Why are they so adamant of demanding payout, yet refusing to provide any documentation that substantiates their claim of ownership? I mean, within the loan agreement itself, the assignment clause, as shown right here, it states very clearly CIBC can sell the rights to this debt at any time without informing the borrower. So this is all very shady. I mean, if CIBC did in fact own the rights to the contract, then why are they making such a fuss about simply proving it? They would rather have lawyers come out with intimidation tactics to try and get the debtor to lay down than to simply approach this transaction transparently and in good faith and simply prove that they own it so that they can receive the funds. I would say at this point, it appears as though CIBC is attempting to collect money for an asset that they no longer own. Now, let's not beat around the bush here and let's call it as it is. That is fraud. You cannot collect money for assets you don't own, especially not while pretending like you own them. That is the definition of fraud. Now, as soon as we get a response back from Sandy, you guys are going to get an episode 2. But for now, that's all we got for you. Hope you guys have a wonderful day, and we hope you learned something.